SwayamPrabha. Digital India. Educated India.
Good morning, students. My name is Shalini Sharma. I am working professional in child rights, having more than 5 years experience of working as chairperson Child Welfare Committee and more than 1.5 year in my present role as member Juvenile Justice Board. Today, I am here to take a course on Juvenile Justice Care and Protection of Children Act 2015, and our module for the day is Rehabilitation and Social Reintegration of the Children, Social Investigation Report, Individual Care Plan, and we will also understand Social Background Report. Before moving further, let's recap till date what we have studied. We have studied the growth of Juvenile Justice Act in India before it attained its present form. We also studied about child welfare committees, statutory bodies to deal with children in need of care and protection. We also studied about Juvenile Justice Board, statutory bodies to deal with the cases of children in conflict with the law. We also studied about child care institutions, their classifications and mandatory services provided by them. We also studied about 3 kinds of non-institutional services: sponsorship, foster care and aftercare. We also studied about adoption, which is one of the most important topics which attract maximum interest from the people and stakeholders alike. We also studied about 2 distinctive features of Juvenile Justice Act: preliminary investigation and age of juvenility. We also studied about offences committed against children and roles and responsibilities of various stakeholders involved in implementing this act, and we talked in detail about the institution of district magistrate, district child protection officer, Special Juvenile Police Unit and District Child Protection Unit. Before moving ahead with today's topic, let's have a little background of this act. Children are a nation's supreme asset. India has enacted Juvenile Justice Act in furtherance of our constitutional and international obligations. The Juvenile Justice Care and Protection of Children Act 2015 is a comprehensive law that replaced the earlier Juvenile Justice Act of 2000. The Act provides for the care, protection and treatment of children who are in need of care and protection and who are in conflict with the law. This Act also deals with the adoption of children, their rehabilitation and social reintegration. This law looked at social aspects of juvenile delinquency and prescribed a reformative and rehabilitative legal framework for its treatment. The Act sets up the juvenile justice boards and child welfare committees at the district, city and block levels to handle cases related to children. It also outlines the procedures for dealing with children in conflict with the law, including their trial, sentencing and punishment. The Act recognizes the principle of restorative justice and promotes rehabilitation and reintegration of children either in conflict with the law or in need of care and protection. Section 39 of the Juvenile Justice Care and Protection of Children Act 2015, and the marginal line of this section is process of rehabilitation and social reintegration. Students, now let's try to understand what this section says. 39 subclause 1. The process of rehabilitation and social reintegration of children under this Act shall be undertaken based on the individual care plan of the child, preferably through family-based care such as by restoration to family or guardian, or without supervision, or with sponsorship, adoption or foster care. Students, this section says that all the functionaries under this Act must ensure that the child must return to the happy and the normal and protected environment. And the process of rehabilitation and social integration must be taken on the basis of the individual care plan. And the rehabilitation and the reintegration here means putting the child back into the family, biological family, or in the care of a guardian, or with supervision. Maybe aftercare is recommended, or without supervision, or sponsorship or adoption or foster care. For providing child a family, these options of adoption and foster care should also be included. Provided that all efforts shall be made to keep siblings placed in institution or non-institutional care together unless it is in their best interest not to be kept together. So, students, here a provision which says that for the purpose of rehabilitation and social reintegrations, siblings must be kept together. Either they are being placed in a family, or if they are placed in an institution, the siblings should be kept together. But there is an exception if keeping them together is not in their best interest. 39 subclause 2 says, for children in conflict with law, the process of rehabilitation and social reintegration shall be undertaken in the observation homes if the child is not released on bail, or in special homes or place of safety or fit facility or with a fit person, if placed there by the order of the board. Now, subclause 2 says that if a child in conflict with the law and for his rehabilitation, if the child is not released on a bail, his rehabilitation is to begin in the observation home, and if the child has been put by the order of the JJB or the children court in a place of safety or a special home, his rehabilitation will begin there. The purpose of the Act is not the punishment of the child, it is for the rehabilitation and the reintegration. The in charge of the observation home and the special home and the place of safety must ensure that they must take all the steps which are necessary for the social rehabilitation and reintegration. Maybe who are not placed in families for any reason may be placed in an institution registered for such children under this Act, or with a fit person or a fit facility on a temporary or long term basis, and the process of rehabilitation and social reintegration shall be undertaken wherever the child is so placed. So, subclause 3 says, if a child cannot be restored back to a family for any reasons and is placed under the order of committee in an institution, the institution or the fit person or the fit facility, the in charge of these facilities also must take necessary steps for the reintegration and the rehabilitation. The children in need of care and protection who are leaving institutional care, or children in conflict with the law leaving special homes or a place of safety on attaining 18 years of age may be provided financial support as specified in section 46 to help them to reintegrate into the mainstream of the society. So, this section says after the completion of term or after the completion of 18 years of age, if a child is leaving the institution, maybe child in conflict with the law or the child in need of care and protection, he, if requires, a financial support can be given to him till the age of 21 years by the name of aftercare. Now, let us try to understand this section with a case study. Imagine a 14-year-old girl named P, who was found living in the streets without any known family. The Child Welfare Committee, after inquiry, declared that she is a child in need of care and protection as defined in the Juvenile Justice Act. Now, according to section 39, subclause 1, the authorities have to create an individual care plan for the girl, aiming to reintegrate her into society. The first attempt of any stakeholder is to trace her biological extended family for possible restoration. However, it came to fore that both her parents are dead and nobody in her community wants to keep her. So, the restoration is not possible in this case. And now, she cannot be placed with the family. The CWC would look for a registered institution, fit person or a fit facility where she can stay either temporarily or for long term. The goal remains the same, to rehabilitate her and to integrate her back into the society to make her a useful citizen of the country. Lastly, after turning 18 years, when she is about to leave the institution, she may receive financial support in the shape of aftercare to assist her reintegration into mainstream society by helping her to learn any vocational training if she is studying to continue her education till she is grown up enough to earn her livelihood. Now, let us see what the section 40. Marginal line of the section 40 is restoration of child in need of care and protection. The restoration and protection of a child shall be the prime objective of any children home, specialized adoption agency or open shelter. The children home, specialized adoption agency or an open shelter, as the case may be, shall take such steps as are considered necessary for the restoration and protection of a child deprived of his family environment temporarily or permanently, where such child is under their care and protection. So, this section says कि if by any chance a child is placed in an institution, the prime and the main objective of that institution is the restoration of the child back in the family. They should make all the efforts to trace the biological family of the child, and meanwhile the child is staying in an institution, he should be protected from all the abuses. The committee shall have the powers to restore any child in need of care and protection to his parents, guardian or fit person as the case may be, after determining the suitability of the parents or guardians or fit person to take care of the child and give them suitable direction. So, here a mandatory duty has been given to the committee to restore the child back to the family, and family has been defined for the purpose of restoration is parents, adoptive parents, foster parents, guardian or a fit person. After the inquiry, if they are found fit, the committee can hand over the custody of the child, they can give them directions also for the take care of the child in future. The committee shall submit a quarterly report regarding restored, dead and runaway children to the state government and the district magistrate in such form as may be prescribed. In this section also a mandatory duty is made upon the Child Welfare Committee to share the data of the children found dead, missing in their district with the district magistrate and with the state government also. Now, section 95, transfer of a child to a place of residence. Sometimes we encounter children who are not from our district and they come from some other district, and if such case is present before Child Welfare Committee and the Juvenile Justice Board, their aim should be to return the child back to the same socio-economic or cultural conditions. Let's see what the section 95 says. Subclause 1, if during the inquiry it is found that a child hails from a place outside the jurisdiction of the board or committee, as the case may be, shall, if satisfied after due inquiry that it is in the best interest of the child and after due consultation with the committee or the board of the child's home district, order the transfer of the child as soon as possible to the said committee or the board along with the relevant documents, and following such procedures may be prescribed. Now, as I said earlier, if the child produced before the board or committee is not from their district, they must, keeping the best interest of the child in mind, first contact the Child Welfare Committee and the board of the concerned district, of the home district of the child, and after the inquiry, if it is found that the child should be restored back to the home district, the committee here must make provisions for it, provided that such transfer can be made in case of a child in conflict with law only after the inquiry has been completed and final order passed by the board. Here a proviso is given that if a matter of transfer of a child is concerned to the child in conflict with the law, it can be given only in this circumstance that inquiry against the child is over and the final order has been passed by the board. Then board can order for the transfer of the said child. Provided further that in case of a interstate transfer, the child shall be, if convenient, handed over to the committee or the board, as the case may be, of the home district of the child or the committee or the board in the capital city of the home state. Sometimes a child may belong to a very far flung area. It is not possible for CWC or SGPU to arrange a transfer of the child immediately to that area. In this circumstance, CWC can ensure that a child can reach the state capital, and after reaching there, the concerned CWC can make arrangements for such child. Once the decision to transfer is finalized, the committee or board, as the case may be, shall give an escort order to the Special Juvenile Police Unit to escort the child within 15 days of receiving such order. The child has to be sent back to hometown along with the Special Juvenile Police Unit, and within 15 days of receiving such order, the order has to be shared with the Special Juvenile Police Unit, and provided that if the child who has to be sent back is a girl, a women police officer has to escort her. Provided further that where a Special Juvenile Police Unit is not available, the committee or the board, as the case may be, shall direct the institution where the child is temporarily staying or district child protection unit to provide an escort to accompany the child during the travel. Where Special Juvenile Police Unit is not set up, the committee, keeping the best interest of the child in mind, can order the institution or can order the district child protection unit to arrange an escort for the child so that he can be restored back to his hometown at the earliest. The state government shall make rules to provide for travelling allowance to the escorting staff for the child, which shall be paid in advance. So, all the expenditures are to be borne of the travelling of the child or the SGPU are to be borne by the state government. The committee or the board, as the case may be, receiving the transferred child will process for restoration or rehabilitation or social reintegration as provided in the Act. Now, the committee which will receive the child will initiate with the rehabilitation and the social reintegration plan as explained in this Act. Let us understand this also with a case study. Imagine a 10-year-old boy named R who lives in Delhi alone and is found involved in a minor theft and is brought before the Juvenile Justice Board, Delhi. During the inquiry, it is discovered that R is originally from Kanpur. The JJB Delhi, after concluding the inquiry and considering that it is in the best interest of the hour to be repatriated to the Kanpur. After consultation with JJB Kanpur and also decides to transfer the case to the JJB Kanpur. Following section 95 subclause 2, since the boy has to send to the Kanpur, the concerned JJB will direct the special juvenile police unit to escort the child within the 15 days. And upon arrival in Kanpur as per section 95 subclause 4, the JJB there takes a charge and plans for the rehabilitation and the restoration of the child as per the provisions explained in this act. Now, let us understand these three important forms: social inquiry report, individual care plan and social background report. Before understanding these plans, we cannot go ahead with the restoration and the reintegration of the child. Everything in individual indulges has a basis of a series of circumstances that led him to do what he did. The focus of the social investigation report is to identify and understand the circumstances of the child in question and what might have led to the alleged crime. So, social investigation reports give us a little brief history of whatever has gone into the child life till now. The social inquiry report are still regarded as sine qua non in deciding the matter of children, as it helps to comprehend the overall personality of the child produced before us. Social investigation report, individual care plan and social background report. We need to understand very clearly that whenever a child comes in contact with the juvenile justice system, we have to consider him a child in difficult circumstances. And we also have to ensure that child is restored and reintegrated back in or with her or his family at the earliest. We also have to ensure that his dignity and self-worth, which has been lost in the process, is restored effectively. Social investigation report, individual care plan and social background report are the prerequisite documents which help in deciding cases of children. Rehabilitation and reintegration of children as defined in JJ Act is not possible without these mandatory forms. When any child is produced before the juvenile justice system, it means that he or she is in difficult circumstances. The rights of the child are affected and the juvenile justice system has to reinstate the dignity of the child back to him. Juvenile justice system focus on process of rehabilitation and reintegration of the child. To decide the exact course of action in this process, social investigation report of a child is a prerequisite. The Juvenile Justice Act 2015 provides for rehabilitation and reintegration of children in different sections of the legislation, including its general principle. Chapter 2 of the JJ Act 2015 outlines the general principles to be followed in administration of Act. Some of them especially relevant for non-institutional care are: Principle of dignity and worth. All human beings shall be treated with equal dignity and rights. So, students, while preparing the individual care plan, the social background report and the SIR report, the one who is preparing the form should always remember that all these acts are done in furtherance to restore the child dignity back to him. Principle of participation. Every child shall have a right to be heard and to participate in all processes and decisions affecting his interest, and the child's view shall be taken into consideration with due regard to the age and maturity of the child. So, principle of participation says that we should give chance to the child to participate in the proceedings, and these 3 forms about which we are discussing today also gives us a child opinion about the knowledge of his circumstances, about his aspirations and hopes and his desires from the system. So, in another way, the child communicate to the board or the committee through these forms. Principle of best interest, which is the soul of the juvenile justice system, and it is very important. So, anybody who is filling these forms or reading this form should know that all this is for the best interest of the child. Principle of safety, which is also a very important principle of the Juvenile Justice Act. It says that while filling these forms or while sharing the information on these forms, it is important that the child should stay safe and his safety should be given the priority. Positive measures. All resources ought to be mobilized, including those of family and community, for promoting the well-being, facilitating development of identity and providing an inclusive and enabling environment to reduce vulnerabilities of children and the need for intervention under this act. So, this act says that the government and the community must utilize all their resources for the best interest of the child. So, while filling up these forms, we should know that it has to ensure the best interest of the child. Principle of non-waiver of rights, and this also says that the filling up of these forms is mandatory and we have to sometimes counsel the family, counsel the neighborhood, counsel the school teachers for their willingness in the cooperation for filling up the forms. Principle of repatriation and restoration, which is also a backbone of this act, and these filling up of these forms with a good intent and with a clear mind help us to repatriate and restore the child back into his or her family. Now, what the term social investigation report means? It means the report of a child containing detailed information pertaining to the circumstances of the child, the situation of the child on economic, social, psycho-social and other relevant factors and the recommendations thereon. So, the definition of the term social investigation report is self-explanatory. It says that it should give a picture on the child economic, social, psychosocial and other relevant factors, and it should also give the recommendations to bring the child back into the mainstream. Now, who is responsible for preparing SIR? The committee shall assign the case to a social worker or a case worker or a child welfare officer or to any recognized non-governmental organization for conducting the social investigation under subsection 2 of section 36 of the Juvenile Justice Act through an order in the form 21, and the Juvenile Justice Board shall obtain a social investigation report in form 6 prepared by probation officer or a child welfare officer or a social worker under Rule 10 subclause 9, Rule 64 subclause 1, and they can make that order in form 5, Rule 10 subclause 2. Significance of conducting social investigation report. SIR is a crucial in the case management process. It helps us in the management of the case as it gives us a picture of the socio-economic conditions, as it gives us the picture of the relationship of the parents vis-a-vis child, relation of the siblings of a child with him, peer pressure, the attitude of the school teachers, the neighborhood. So, SIR reports help us to understand the clear picture of the child. The Juvenile Justice Act mandates that prior to disposition in any case involving a child, the caseworker should provide Juvenile Justice Board and CWC with a social investigation report. So, the submission of a social investigation report to the Juvenile Justice Board and the CWC by the social worker is a mandatory clause. Social investigation report assists the Child Welfare Committees and the Juvenile Justice Board to make an inquiry of child in conflict with the law and child in need of care and protection. To pass the final order for the child on rehabilitation process and consider the options available for individual care plan. So, it is not possible for Child Welfare Committee or the JJB to pass an order without understanding or reading the SIR form. Modes of social investigation. How we conduct a social investigation of a child. First is to interview with the child. As I said, right to participation, this is how the child participate in a case or an inquiry pending against him or for him. Visit to the family and neighborhood, meeting with the teachers, peers, employers, observation. Medical examination, the social worker can also observe the behavior of the child and can give recommendations thereof. Medical examination, we have to see that the child is not suffering from any disability, it could be hearing, it could be any. Collecting expert opinion, verification of relevant documents. Sometimes the children do not have their age verification documents. The social worker, while conducting the SIR, can help the child in obtaining the relevant documents and can also get them verified. Social investigation must contain accurate information. It should be multidimensional, facts and non-judgmental. Social investigation report must contain the accurate information. It should not be a hearsay and it should be a holistic. It should not be considered as a time pass work and just social worker thought of going there in a one meeting and thought that I will fill up the form on my own. No, she has to complete this work on the basis of the facts and she has to be non-judgmental. In many cases, we have observed that the children in conflict with the law, people get little biased. But while preparing this social investigation report, you have to remain non-judgmental. Indicative and self-explanatory, it should be clear. All the parameters and the indications should be clearly explained. It must provide an assessment of the family situation of the child in detail, and the social worker has to meet the family and assess them personally to reach the effective conclusion about the family conditions. Explain whether it will be in the best interest of the child to restore him to his family. So, this is the most important question before restoring the child back to the family. It has to be seen that we do not put the child back into more trauma if he has run away from a home and does not want to return back, and if the social worker does not prepare the SIR form in a true spirit, as there is possibility that on the basis of this report CWC or JJB can restore the child back in the family and can put the child into more danger. So, while preparing these essential documents, one has to do her duty very diligently. Now, SIR has three parts. First part deals with the details of the family. The probation officer, the child welfare officer and the social worker to give data or the information regarding to the close relatives in the family, delinquency record of the family, is the father involved in some antisocial activities, what is the behavior of the mother, brother, everything, and their economic status, their ethical codes, the family attitudes toward religion, everything has to be explained in the first part. And the second part requires the probation officer, child welfare officer and the social worker to provide child's history, his physical conditions, his habits, his interest, his personality traits, neighborhoods, neighbors report and school employment. If any friends in child being subjected to any form of abuse, circumstances of apprehension of the child, and in what circumstances the child was apprehended, any friend of the child has ever been subject to any abuse, everything. Mental condition of the child has also to be explained. In third part, it is the most important, the result of the inquiry, where the probation officer, child welfare officer and the social worker is required to inform the board about the emotional factors, physical conditions, intelligence, social and economic factors, religious factors, rehabilitation and reintegration of the child. This can be given only by analyzing all the factors involving the child and by adding it to his or her own wisdom, experience and imagination of the probation officer, child welfare officer and the social worker. After filling up the form part 1 and part 2, the social worker has to apply his or her own wisdom to analyze the situation of the child and give his or her own recommendations thereof. To collect the information for SIR, all the concerned officials are required to visit the home and locality and school of the child several times. It requires great patience, skill and considerable amount of time. As I said earlier, it is not a one-day job just to go there and to fill the form. Report should be speaking document. It must also express your wisdom, your understanding of the case. Probation officer, child welfare officer and the social worker cannot give generalized or vague answers, and they have to give definitive answers on cause of child becoming involved in offence and how child got into difficult circumstances. The social worker has to explain all the causes after which the child entered into delinquent behavior. Now, this is how a social investigation form looks. A form 6 is for the children in conflict with the law, and similar form is also for the child in need of care and protection. Almost they are 50% same questions, but few questions, almost for 10 questions are different for children in need of care and protection almost. Now, let us understand what is social background report or SBR. Social background report means the report of a child in conflict with the law containing the background of the child prepared by the child welfare police officer. Now, this is a form which is exclusively for the child in conflict with the law, whereas SIR form is both for the child in need of care and protection and child in conflict with the law. And social background report form is prepared or filled by the child welfare police officer. As per Juvenile Justice Act, a social background report of a child in conflict with the law should be prepared by a child welfare police officer posted in each police stations. When police apprehends a child, the custody of that child is handed over to child welfare police officer or a special juvenile police unit. The child welfare police officer prepares a social background report of the child, where in it's mentioned the reasons for apprehension, why custody of the child is important, what offence has been committed by the child, was the child alone or was he in the group of people committing the offence. The SBR form has to explain why the child welfare police officer wants the apprehension of the child, under what circumstances the offence has been committed, was the child alone or was he with the other adults. SBR report contains in detail the circumstances under which the child was apprehended. Social background is submitted before Juvenile Justice Board by child welfare police officer, and it serves as an important tool for the juvenile justice boards in understanding the circumstances under which the alleged offence was committed. Now, this is how a SBR forms look. Here we can see the two columns A and column B. Here provision is made to for the good habits or the bad habits of the child, according to which the JJB can ascertain the child is in the influence of bad company or not, and it is signed by the child welfare police officer. So, I will explain the importance of a social background report with an example. A child was produced before the Juvenile Justice Board for charges of stealing some food from a shop, and during inquiry and after going through the social background report, it came to the fore that the child is staying alone and his sister is ill at home. Parents have run away and abandoned them. The child did not have eaten anything since long, and he committed theft of food just to give food to his sister. So, under these circumstances and after going through the SBR form, it was presumed that the child is not in conflict with the law, but child in need of care and protection. Based on the report of SBR, the JJB can declare the child as child in need of care and protection and send it to the Child Welfare Committee for further appropriate action as they deem fit. Now, let us study the another important form which is mentioned in the Juvenile Justice Act, that is Form 7, Individual Care Plan. What is individual care plan? Now, let us imagine in a hypothetical situation. You are ill and you go to a doctor for treatment. What kind of a questions doctor will ask? He may ask you many kinds of questions, including what you have eaten in the morning, how long you have been ill. He can ask the health details of your parents, your grandparents also. He can physically examine you, he can prescribe a medicine on the spot, or he can advise you to get admitted in the hospital. Probably he will advise you to get an X-ray. There are so many options. After examining you or after going through your past history, doctor can recommend you. Now, think about a child who is about to join child care institution or who is present before Child Welfare Committee or the Juvenile Justice Board as the same patient who is not well, and our duty as a doctor is to know what treatment he would require for the future. So, for this the individual care plan is prepared, and how we will address the needs of that child in future, even for this the individual care plan is prepared. The definition of the individual care plan is found in Rule 2, Sub-Rule 9. Individual care plan is a comprehensive development plan for a child based on age and gender specific needs and case history of the child, prepared in consultation with the child in order to restore the child's self-esteem, dignity and self-worth, and nurture him to be a responsible citizen, and accordingly the plan shall address the following, includes but not limited to the needs of a child, namely. So, individual care plan is a comprehensive plan, it is a holistic plan which is made in consultation with the child. So, it gives him a right of participation, and the purpose of the individual care plan is to restore back what has been taken away from him. It shall include health and nutritional needs, including any special needs. There may be chances that a child who is presented before us or whom we are placing in a child care institution is a person or is a child with the special needs, and in this individual care plan his special needs, if he has hearing problem, if he has a skin problem, if he has any eye problem, these problems of the child are to be mentioned in the plan. Emotional and psychological needs, this is also an important factor, that he gets scared in the night, that he has some fear or trauma. All these expressions of the child or emotions of the child are also to be shared in the individual care plan. Educational and training needs, if a child who has been brought before us is a student and while his stay in the institution, his educational needs are to be taken care of. Leisure, creativity and play, what he likes, how he wants to spend his time, what games he play. All these things are also to be expressed in the individual care plan. Protection from all kinds of abuse, neglect and maltreatment. Individual care plan must also ensure that the child remains safe from abuse, neglect and maltreatment. He is able to share his emotions and expressions clearly. Restoration and follow up. Individual care plan also helps in the restoration and follow up. What child thinks and believes about the family, whether he misses them, whether he wants to go back to them. All these things also have to be included in the individual care plan. Social mainstreaming and rehabilitation. Individual care plan should also endeavor to provide the skills and the rehabilitation that he should be a contributing citizen of a country. They should aim to provide such skill, such life habits to the child. For whom this ICP form is for and who will fill this form? All dispositional orders passed by the board shall necessarily include an individual care plan for the child in conflict with the law concerned, prepared by a probation officer or a child welfare officer or the recognized voluntary organization on the basis of interaction with the child and his family wherever possible. So, in case of a child in conflict with the law, this individual care plan, the word here is shall necessarily. There is no option. This individual care plan has to be prepared by the probation officer or anybody, but the form has to be prepared. And after the interaction with the child or wherever the family of the child is available in consultation with them also. The dispositional order passed by the children court shall necessarily include an individual care plan. Even the children court cannot give any order against the child without obtaining the individual care plan. The final order passed by the children court shall necessarily include an individual care plan for the child as per Form 7 prepared by a probation officer or a child welfare officer or a recognized voluntary organization on the basis of interaction with the child and his family wherever possible. Even the final order to be given by the children court shall necessarily include the individual care plan, which is an insight for his future development. The committee shall direct the person or organizations concerned to develop individual care plan to include suitable rehabilitation plan. How do they plan to rehabilitate the child in future? Those recommendations should also be included in the individual care plan. The individual care plan is prepared for every child in the institutional care. As I said earlier, the individual care plan is a mandatory requirement and it has to be prepared for each and every child who is staying in an institution. And it should be prepared with the ultimate aim of the child being rehabilitated and reintegrated based on the case history circumstances. As I explained, all the acts we done in furtherance of the Juvenile Justice Act is to ensure the child's best interest. At the time of final disposal of the case, the committee shall incorporate in the order of disposal an individual care plan of such child prepared by the social worker or a child welfare officer. Even the child welfare committee, while passing orders of the disposal, have to take the individual care plan of the child. They cannot pass an order without considering the individual care plan for the child. It is for any child that comes in contact with the justice system, either needing care and protection or in conflict with the law, needing institutional care. As I said earlier, the ICP is prepared for both kind of children in need of care and protection and in conflict with the law, but those children who are staying in an institutional care. ICP is to be done based on case history, age and gender, specific needs and case history of the child prepared in consultation with the child and the family member. Individual care plan is prepared on the basis of the case history and is also after the interview with the child and his family. ICP is done in order to assess the child's need to restore back his or her self-esteem, dignity and self-worth and shape him into a responsible citizen. So, the aim of the ICP is to shape the personality of a child and to make him a responsible and useful citizen in future. This is how an individual care plan looks like. It is same for child in conflict with the law and it is same for the child in need of care and protection. The list of things we need to address in individual care plan is health and nutritional needs, including special needs. If a child is specially abled, his special requirement is to be taken care of. Let us assume if a child is malnutritioned, he should be given special diet to increase his weight and his health issues. Emotional and psychological needs are to be taken. If a child is staying alone, if he has gone through any trauma in the family, his emotional and psychological needs must be taken care of. Education and training needs, if he is a school going student, he should be able to continue his education. If he hasn't ever been to the school, he must be provided any skill while he is staying in a child care institution. Leisure, creativity and play, protection from all kinds of abuse, restoration and follow-up, social mainstreaming, life skill training. Who has to fill up this form? The probation officer, child welfare officer, case worker and the social worker appointed at DCPU shall be responsible for the preparation of the individual care plan, and individual care plan is in the form 7 of Juvenile Justice Model Rules. Here, an important thing about ICP is ICP ought to be reviewed every fortnight in the first 3 months. When a child is placed in an institution and after every 15 months his individual care plan is to be reviewed, and if child is staying for more than 3 months now, it can be reviewed every month thereafter, but for the first 3 months it has to be reviewed after every 50 days. How to develop an individual care plan? It has 4 parts, part 1, part 2, part 3, part 4. Part 1 deals with the before admission, that means the brief history or the case history of the child, what brought him in an institution. After admission, we have to see what goals we want from that child, what challenges the child is facing and how to help him overcome those challenges. Before discharge, if the child is ready to be discharged or to restore to the family, we have to plan that action accordingly. And after discharge, follow up. Follow up is also necessary to ensure that the child is happily and comfortable in a family. The way forward. It should be recognized that if individual care plan and social inquiry report and the social background report are effectively implemented, they would go a long way in preventing juveniles from falling back into crime. If the individual care plans, social inquiry report and the social background report can be given effect, it would also reduce the necessity of institutionalization for the children. If these plans are effectively implemented, they can help in securing the objectives of the Juvenile Justice Act. So, we cannot undermine the importance of these important forms in the implementation of the Juvenile Justice Act. These 3 forms together gives a deep insight of the case and can help child welfare committees and JJBs to take an effective action for the future needs of the child. Now, let us see what the court's opinion about these important forms. In Dharamraj versus State of UP, where an accused was threatening a girl for marrying her by force, the court had held based on the social investigation report that the releasing him will expose him to psychological and moral dangers. It will also be concluded through the report that he is likely to come in contact with the other criminals and thus his release would be of no use. So, here the court took the cognizance of the social investigation report and his release from the jail was delayed. In Vishnu versus State of Haryana, the child who was in a conflict with law is also the petitioner and relied on the Vishwas Bhandari versus Punjab case and contended that the courts in his case did not consider social investigation reports. The court considered this and went ahead with evaluating his social investigation report, which concluded that his relation with his parents and peer were cordial and was a normal child and committed the alleged crime under the influence of peer group pressure. So, in conclusion, the objective of having a separate legislation for the juveniles is to reform and rehabilitate these young offenders and to provide them care and protection to vulnerable children. The intent of this act is not retributive but restorative, and the shield of this act must be provided to the children by them. So, with this thought, children, I will conclude this lecture for the day. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I will be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samara. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samara and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samara to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet.